And he says, Noah, you just went from a lawyer that I've never heard of to a lawyer making incredibly unethical arguments that I have sent to everyone in my firm, Varnum. And he says, everybody at my firm now knows how unethical you are. And we file our motion to dismiss. And in our motion to dismiss, we attach that email.
Welcome to another great episode of Cases Gone Wild with me, your host, Jon Marko of Marko Law. We have a great show for you today with my good friend, colleague, co-counsel, co-trial counsel, responsible for the second largest religious accommodation verdict in the history of the world, the entire world. Noah Hurwitz is on the program with us today. On my show, we talk about the craziest, wildest, most insane, unbelievable cases on Cases Gone Wild. If you like the show, please like us, give us thumbs up, reviews. You can watch us on our YouTube channel, our Marko Law YouTube channel, or on all your favorite platforms. Please share us with your friends and give us feedback if you like the show. Noah Hurwitz, welcome to the show, my friend. Good to see you, buddy.
Hey, John, thanks for having me. I appreciate it.
So, Noah, you a very successful career. You have Hurwitz Law, which is in Ann Arbor. I know you do stuff all over the country, but you have a big Ann Arbor presence, I know.
Yeah, we do. We have 5 attorneys besides me in Ann Arbor. I started that firm 3 years ago, and we're just trying to grow something like you did.
Well, you're doing a great job. I met you. We somehow got in touch. You reached out to me, and you had been pioneering these religious accommodation cases related to the vaccine. People who, for religious reasons, didn't want to get vaccinated. That was kind of your brainchild.
That was. So right about when I started our firm, we started getting calls, and there were individuals, employees who had been forced to get, like a lot of people, like we were in various circumstances, asked to get a COVID-19 vaccine. And these are individuals who pushed back for religious reasons. They had been sort of, coined the anti-vaxxers, the Trumpsters, right? There was a lot of people that were not very happy with them. For me, keeping my eyes wide open, it was always a chance to practice an area of law that I thought I could have success in. That's what we do. We're looking for areas where we can expand the law for everybody, through good cases. And religious accommodation cases were just very rare because they favor the employee, and companies typically don't mess with you when you ask for a religious accommodation. So here we had a lot of people asking for accommodation, a lot of people being denied, and that gave us this opportunity to help them at a time when there was a lot of, we're both part of different message boards, and a lot of attorneys saying, hey, I'm not going to help these people.
Right.
And I looked at it as a different situation. It wasn't, hey, am I going to help them or not? It's, has the law been broken? And once we realized that it had, we wanted to jump on board and help people.
Well, you were very brave, and I would consider you like a pioneer on this. Obviously, COVID-19, unprecedented situation. A lot of times, I know you do a lot of focus almost exclusively on employment law, right? And civil rights.
That's right, yes.
And, when there's these great tumultuous events, such as pandemic, or these other shakeups, recessions, depressions, or just about any shakeup, there's a lot of labor force shakeup, which can create a lot of employment litigation, I find. I don't know if you've had similar experiences.
Absolutely.
But certainly with this religious accommodation, so many people had just turned these individuals away and said, I'm not going to touch this case for whatever reason. The case might be too hard. I don't think you have a case. I'm not going to take a chance. You did take a chance. And how many total religious accommodation cases did you have, Noah?
We had, in terms of individual plaintiffs, we had at least like 400 or 500.
Wow.
Yeah.
And most of these, a lot of people, and I know through our work together, they couldn't find a lawyer to help them.
No, they couldn't find a lawyer. And so as we started taking these cases on, people started flocking to us, and we looked at this again as an opportunity to change the law, because religious discrimination is one subset of discrimination. You help people. You help people who are being denied their religious freedoms. You're going to help people with all kinds of freedoms.
Well, you took a great risk, I think, because it was, as we talked about on the show before, when we do plaintiff's work, it's our own money that you have to put up,
right? Your
own time, and if you lose, you get a big fat goose egg. You get nothing, right?
That's right.
So, bravo to you, and I'm proud to have helped on some of the cases and worked along with you on some of the cases. Before we talk, and we're going to talk about kind of this world record-breaking case. It should be in like the Guinness Book of World Records for lawyers or something,
right?
But tell us about your background. You came from the dark side, so they say, right?
Right. So I have the background itself is sort of interesting, because I start off out of law school in 2010, which the New York Times called us the class of death, because all the lawyers coming out in 2010 were in the middle of a bad recession.
Yeah, I was in 2008.
Right.
And they were taking offers away to
That's
kids.
Right. That's right. So by 2010, I was in a 3L class. The professor said, "How many of you have jobs lined up?" and nobody raised their hand. So that's the climate. So I come to Detroit. I'm working for my uncle, who's a civil rights attorney in Detroit, and I do that for a year. I get poached to, I got to make some money at some point, and I'm not making money right now in the situation I was in. And so I go over to a little boutique law firm where I'm doing defense work. I then go from the defense.
Employment defense?
Employment defense, okay. Yeah. So I then go from employment defense to a big law firm, Dyke & McGossett, and now I'm doing big law employment defense.
One of the biggest defense firms in Michigan, for sure. I think it's like top 3 or something.
Yeah, one of the biggest firms in Michigan, for sure.
And so you were there, and then you ended up, didn't you go to Quicken Loans for a little bit?
Yeah, so what happens is I'm looking for sustainability. I'm representing defendants. We'll talk about this more, but when you represent defendants, you can win, but you never really win, right? You're representing a company. It's sort of a sterile environment.
Yeah.
And so they expect to win. And when you do your job and you get them a win, it doesn't feel all warm and fuzzy inside. Right? You're not filling
you're
up.
representing like big corporations, right?
That's right. All the big companies. And what we're doing is we're defeating employees, right? We're getting cases dismissed. We're helping the company send a message that the employees are not going to exercise their rights, that the employees are going to sort of sit there and take it, and we're going to do what we want to do. And so even when you accomplish your goal in that role, you don't feel like you're doing much for the greater good.
And what a lot of people don't realize is, in the employment context, the deck is stacked against the employee. Like, you leave this studio, you get hit by a car, somebody runs a red light. That's an easy case, right? I mean, somebody ran a red light, that's a tort case, that's easy. But employment law has 100 little exceptions. They only need to poke one hole in your case and the employee loses, right?
That's right. We've got a situation where for decades, we have the law getting worse and worse for employees. There's a number of factors of that. I'm kind of curious what you think the biggest factor is. But one way to start is to think about it this way. You and I are big fish in a little pond, because when you have an employment situation, something bad happens at work, you're going through one of the worst things you've ever been through in your life. You look at you Google employment law, right? And you only find so many people. Right. It's really, there's a huge lack of employment law attorneys in the state of Michigan compared to other areas in the country.
Right.
And so when you've got something going on, there's not many places to turn. Now you look at the opposite of that, and there's a ton of attorneys who do employment defense, because every single firm, every big firm, and a lot of little boutique firms are trying to get that work. They're doing insurance defense. They're representing big companies. And so when we take on a case, typically it's one or two of us against 3, 4, 5 of them.
Yeah.
And
or more in our case.
Or more. Right. And so, no, absolutely, the deck is stacked. And then, when we go even a little bit farther back, we know that, we have judges who typically will have more corporate interests. And if anything else, maybe it's just that they don't want their docket crowded with all these employment law cases.
Yeah.
And so for now decades, the law has gotten progressively worse and worse and worse. And so it's an exciting thing. It's a difficult thing, but it's our job to really reverse that trend and try to give employees a fighting chance.
Yeah. Well, you've done a great job of it on this. Before we talk a little bit about some of your perspectives on it, this religious accommodation case that we did together in federal court with Lisa Domsky, it brought its own challenges, right? You kind of flipped the script due to the subject of religious accommodation. So normally when we're looking for, we'll take jury selection, for example.
Yeah.
Normally when you look for jurors, you might not want very conservative jurors sitting on your jury, very religious jurors, depending on the case. I don't use religion as a disqualifier, but depending on the case, this was different.
It was absolutely different, and it was different in kind of an exciting way. And the idea was that we have a lot of individuals that are in this jury pool who are going to have spirituality, and the ones that have spirituality, we think, okay, those are going to be good jurors for us because they're going to see our side of the story. And so, but that's not it. We also have the jurors who might be agnostic, might be atheists. And they're going to be also potentially a good juror for us because they know that they want the freedom to not have a religion. So it's whatever side you're on, right? You have faith, you don't have faith. Everybody wants the freedom to make that decision. So it's very different.
Choose for themselves,
yeah.
right? Yeah.
So it's totally different than these other discrimination cases where you might be going through something and you feel like it's about something that's sort of very unique to you.
Mm-hmm.
But in these religious accommodation cases, we know that it appeals, the freedom of religion appeals to virtually everybody.
All of us.
Yeah.
Yeah. One thing I felt about trying this case with you was that there was a bigger principle at issue than in a lot of the cases that I do. And that's not to diminish any of the cases I do because it's very important to each and every one of my clients. Somebody gets hit by a car or hit by a truck or something, it can ruin their life.
Yeah.
And that's unique to them. But in this case, it was almost for a higher principle. Did you feel that way too?
No, I absolutely did. And what's funny, John, is I felt that. But when I saw you and the passion you brought to the case, that actually, it moved me too. It was an exciting thing to sort of have these thoughts in my head about how this is going to work, and then see you sort of raise the importance of these issues. And I was, sitting there watching it. It was something I would have paid to be a part of. It was so exciting.
It was a fun time.
It was.
And thanks for including me. And we did a great job. We put in great work, and we still have a lot of great work to do for people.
For sure.
So tell us, you know so much about religious accommodation. You've been kind of living it for years. I don't know if you did before the COVID-19 pandemic.
No, none at all. None at all.
That. So, but the laws vary. Most of the laws, like you said, for employment are now going against the employee, which I think may be in part due to a more conservative federal judiciary, not just here in Michigan, but I think across the country and certainly at the United States Supreme Court. Religious freedom and religious rights is actually maybe an area where it's going to the benefit of the employee. What do you think?
It could be. That was at the outset of these cases, that was our thought process. We thought we were going to be benefited by the law in these cases. And historically, if you look at that, that's been true. The big surprise here is in the last 3 years, employees have been surprisingly losing a lot of religious accommodation cases. And we've sort of helped develop here in the Sixth Circuit, right, in Michigan, Ohio, Tennessee, and Kentucky. We have a little bastion here of an area where religious liberties really mean something. But if you look at how these cases have gone out on the East Coast, out on the West Coast,
yeah,
right, so many other areas, Pennsylvania's been brutal on these cases. And what you're seeing is rights that have long been established. When those rights really start getting exercised by employees, it seems like the judiciary now feels like it has to push back. and they're pushing back against decades and decades of Supreme Court law that benefits the employees. And as a result, we're seeing lots of dismissals. It's something we warn our clients about because our clients think that this is so fundamental, that this should be so much part of the fabric of their rights. And we have to tell them, listen, we're going to do the best we can, but there is now momentum against religious liberties in this country.
So give a primer to those who don't know religious accommodations. What is it? How does it work? And what's the law?
Right. So religious discrimination is sort of our overarching principle, right? We're trying to make sure that nobody's going to be treated differently because of their religious beliefs. However, like the Americans with Disabilities Act, there's an area of law that focuses on the accommodation of your beliefs. So it's discrimination with a little bit of a nuance. And what that means is you're working and you encounter something at work, a policy or a requirement that you have to follow. And now you realize that it conflicts with your religious beliefs. And if that's the case, you're allowed to go to the company and ask for an accommodation. The company, there's sort of a two-part test. The company first has to evaluate whether or not your religious belief is real. Historically, the law has always been very strong on that front and says, basically, if it's spiritual at all, we're going to believe you and we're going to say, yeah, that's a real belief.
So it can be anything, right? I mean, like, Catholicism, Judaism, the mainstream religions, but I think we had people in our case that had very less mainstream religions,
right.
Like what was it, the devil guy?
We had a satanic worshiper in our case. We had somebody who was vegan and talked about their case in a sense of spirituality and not really religious spirituality, but more like nature spirituality.
Like druid type stuff.
Yeah. And so, really interesting stuff and really going back decades, under the law in this country, all of those spiritual beliefs are protected.
Yeah, the First Amendment, which I think we led in our trial, the First Amendment, the very First Amendment to the U.S. Constitution, our founders put in, right, the freedom to practice your religion, right? So
yeah, the free exercise clause.
Free exercise, yep. So what's the law now? Because I know you know what your favorite case is that I learned from.
What's that?
From our time together?
Yeah.
The clothing store that I used to go to in high school when I could save up enough money.
Okay.
Abercrombie, baby.
Oh yeah, right. The Abercrombie case. So, Abercrombie was a great opinion that the Supreme Court handed down just about a decade ago, and in it they said we're going to really fundamentally protect religious beliefs, and we're going to do so. What matters to us is the company in any way, shape, or form going to use your religion against you, and so it kind of takes us to that second part of the religious accommodation test. The first one being spirituality. The second one is, would it cause an undue hardship for the company to give you that accommodation?
So the first part is it real, I guess? Are you religious, right? You can't just say like, hey, I don't want to go to work today because I want to play video games. Like that wouldn't be like a...
I listen, it could be, but right.
It'd be a tough one.
That'd be a tough one.
All right. So the first part is, do you have a sincere religious belief, right?
Right.
And then the second part is it like too much for the company? Can you...
Right. So the second part is actually a test that isn't super well developed because the old rule, and I dealt with this when I was on the side that was representing the big companies, is when somebody typically gave you a religious accommodation request, you just granted it, right? You granted it unless it was going to be a really, really, really awful undue hardship. When you're looking at undue hardship, we're talking about the costs. A lot of times we're talking about the feasibility. Can you do this? Is this going to ruin the company? And so one of your colleagues and I, obviously, we had a trial recently, the attorney Michael Jones, who works with you. And we had a case that was not about really about the spirituality as much as it was undue hardship. So in that case, against a big casino here in Detroit, the casino was arguing that one employee, if that employee was sick because of COVID-19, because
it was a vaccine case.
It was a vaccine case.
He didn't want to get vaccinated because of his religious beliefs.
Right. And they argued if the one employee got sick, which he was more likely to do because he wasn't vaccinated, that was their theory. And if that happened, they were going to have to basically potentially shut down their warehouse. And the jury found in our favor, which was terrific. But
sounds like a made up thing. This one guy. I mean, how many people were in the warehouse?
Right. And when you think about it, you say, well, wait a minute. Yeah, he could have got sick with COVID-19, but he could break his arm. He could have a surgery. He could
The
get
flu, yeah.
Right, he got the flu. He could have cancer. And we have already, in this country, we're lucky that we have some protections for employees that allow for people to miss work. And so just the idea alone that he was going to have to miss work, that wasn't going to be an undue hardship.
Yeah. And you guys won that case.
Yeah.
Against the casino for this. And so, I mean, we've been very successful with these vaccine cases together and these religious accommodation cases together. We did the Domsky case against Blue Cross and Blue Shield.
Right.
Which led to the second largest verdict in the world history on religious accommodation. And I have to tell you, when we first sat down and talked about it, I was somewhat generally skeptical. I got vaccinated, and
right. I did
talked
too.
about this before. Yeah. But working on these with you has really made me appreciate more this right to religious freedom and how important it is. I guess I always thought it was important. I just never thought about it. It never came to be tested, right? I mean, I'm Catholic, right? I go to mass when I want. I don't go to mass when I don't want, I get to raise my kids Catholic as I want. I've never actually had an intrusion into my personal religious beliefs that I've ever felt. But to see what happened to these people and to talk to the individuals and see how it affected them and to go through this trial, it was very emotional for me. I know it was emotional for you.
Right.
To see how important these rights are. And, our theme in the Domsky case was, and in almost all these cases, is that a corporation shouldn't make you choose between your career and your conscience, or your religion and your ability to provide for your family, which essentially is what the defendants did in that case and in a bunch of other cases.
Yeah.
But I felt like we were doing very important work. I don't want to sound too cliche, but I feel like we were doing God's work.
No, and that's understandable. I mean, I think we were, again, it's the goal of what we do is we're dealing with people who are going through the worst things they've ever been through in their lives, typically.
Yeah.
And you want to figure out how you're going to help them. And it's really neat. You're right. I mean, we're doing this important work, and it's important because it just hadn't really happened yet. But you can kind of see a situation where it's going to be happening more and more.
Yeah.
And given that, it's important for lawyers not just to win their individual cases, but to really change the law, which is something I know you've argued in front of Michigan Supreme Court. We're all following, kind of the same cases to see what's going to happen. It's not just about us following the law. Clients too often, they think the law is black and white when it's a ton of gray.
Yeah.
And
especially in employment law.
And so it's really the job of the lawyers to advocate not just for their clients, but for everybody in the future who's going to be impacted by this stuff.
Yeah, 100%. So that's interesting. So what else? We have other vaccine cases that are going to go to trial. And I think now I feel good about the vaccine cases, especially now that things have settled. I mean, I think that there's more skepticism now based on what people have been told. I think that people are more receptive. I mean, I would not want to have to try a vaccine case in the middle of a pandemic.
Right.
But the idea that your employer can force you to put a drug into your body that might go against your sincerely held religious beliefs, I think does not sit well with most people.
No, right. And that's what we're seeing. I mean, the juries we get, they may be for or against vaccination,
right?
But they do appreciate this idea that it's your choice. You're going to get to choose. And, we're in the Sixth Circuit, being in the states that we practice in, we're lucky that we've been able to change the law for the better and make it so in the future, those same rights are going to exist. But that's not the case around the country. And that's just kind of how the law goes. Because when you're representing employees, again, you're up against that momentum constantly. You're up against that momentum of big companies wanting to have protections and be able to conduct their business in a lot of ways. And one of the things I was hoping we get to talk about today is the way in our case, and in our cases that we've seen that happen with statutory limits on the damages we can get from these cases, right? And that's even in the Domsky case, when we get our big verdict, we're staring in the face a rule that was put in place in 1981 saying you're not going to get any more than this amount, right? In our case, it was $300,000.
$300,000 under federal law. Luckily, we have state law, which Michigan's Elliott Larson's pretty good. But this federal law is ridiculous. And look, I hear lawyers say, and just people, well, what's the big deal? Go get another job. Okay. But for some, I find for many of our clients, a job is more than a job. You know, it's an identity. Some of our clients that worked at a place, maybe they poured their entire lifetime into a company.
That's right.
Their identity was there. Their friends were there. Their family. I mean, they consider them family. Sometimes actual family is there. Yeah. And you take that away from someone, it can have disastrous effects on their mental health, not just their income and being able to provide for their family, but you know, how are you supposed to get another job when you're 55 years old? You've been at the same place for the last, 30 years, and now you have to go and try to go get another job.
Yeah. I mean, driving here today, I took a call from a client because like you, we're always working, and I was sort of giving my this speech that I give to my clients, and I tell them that exactly what you just said. Losing your job is like losing a piece of your identity. The longer you're at the job, the more it becomes part of your way of life. It's the sacrifices you make for that job, the times that you don't get to be around your family or your friends that you're giving to that job. And when you lose that job suddenly, and especially when you feel like you were wrongfully terminated, right? This idea that you were having something taken away from you unfairly, it's like a death in the family. I mean, it's a very personal, depressing, anxious, awful type of feeling that, our clients come to us with, and they want to know what they can do with it.
Yeah, I agree. This whole idea that there should be a cap on damages in employment cases is horrible. The cap hasn't been adjusted for inflation or cost of living or anything, right? So it's the same cap. I mean, it's like 40 years old or whatever. So
that's right.
It's ridiculous. And I think, I hear from defense attorneys a lot, Noah. Well, how much money did your client actually lose? Like a woman, for example, a woman's sexually assaulted at work. She complains about it and she gets fired. She doesn't want to sit at home. She wants to move forward for her family. So she gets a new job maybe 4 months later. They say, oh, she only has 4 months worth of wages lost.
Right.
I think that some of these employment cases are undervalued because they're not looking at the human loss and the we call them non-economic damages, but like the pain and suffering. So when a defense attorneys tell me that, I say, okay, I hope you say that to the jury, because it's pretty despicable.
Yeah. Being a defense attorney in another lifetime, I can tell you that even part of our counseling, even the way we talk to our clients, factors in the fact that these cases aren't going to be worth a lot of money necessarily. So a company comes to me and it says, hey, this happened. We don't think we followed the law. We think we did the wrong thing here. What's our exposure, right? What's the worst thing that's going to happen? And everywhere we look in the law, typically mitigates the company's exposure, even though they're not following the law.
Right.
And so it's just a really being now on the plaintiff side of things. It's a sad situation where I know full well that a company is not going to follow the law for monetary reasons. There's just not enough incentive for them to do the right thing, which is why people are always calling us and telling us that things are bad.
Right. So tell us about, you defended, you were on the defense side, right? So you're on the dark side. So tell us about that experience and like how you saw things from the perspective of a defense attorney.
Right. So I would say the most common situation that you get when you're counseling big businesses is they tell you the facts. They tell you the story. They tell you what happened. You're up against, some allegations, and they want to know kind of what's the worst that's going to happen here. Like what's our risk if we do the right thing versus fighting, and they can know they're wrong. They can know they did the wrong thing. They can know they didn't follow the law. They will still fight, and they'll fight because for them it's a cost benefit analysis, right? The same way that they make a cost benefit analysis when they have to decide what parts to order or what contracts to follow. when they look at a situation involving employment law, they're going to do the same thing. And as lawyers, we tell them, hey, yeah, this happened, but this person got a new job. There's a cap on punitive damages, so a jury's never going to be able to put you out of business or anything like that. And based on that information, a company will fight only to send a message. Even when they're wrong, they're going to fight these cases just to send a message, because now you're talking about something that's good business. It's good business to fight cases and send the message that as a company, you're not going to be a pushover. You're not just going to pay everybody who sues you. And that's how the companies, I think, rationalize not doing the right thing.
How'd you feel about that?
It makes you a little bit queasy, right? I mean, it does. It is what it is. You get sort of a shallow sense of pride in this idea that you're doing your job well. But the fact is, you're doing your job well to do something that's not upholding the law, and you're doing your job well to keep somebody else from, some employee who lost their job, from giving them kind of that closure that they needed to move on with their life.
Right. Yeah, it's hard though. It's hard being on this side on employment law specifically, which is probably why that many people don't do it.
Yeah.
Business wise, right? And same thing with caps on damages and things of that nature. It's very difficult.
Yeah.
So, okay, tell us about you're on Cases Gone Wild. So we talked a little bit about a couple cases, but tell us about some of your craziest cases.
Yeah, I mean, going back to the defense side, I'll say kind of one that comes to mind because it sort of follows this message about how a company looks at something. And we had a case where an executive left the company, and a real big
CEO,
like a high level vice president, executive level, and a CEO who's pretty well known comes to us, and he wants to fight, and he wants to send a message. And he wants to send a message that is, you're never going anywhere. You work for me. I want you to be here. I've got a non-compete, right? For those who don't know, non-compete's going to be a restrictive covenant that tells somebody, you've worked here and now you're not allowed to work anywhere that competes against us. Why? Well, because that's good for the company. Okay.
So you're representing the company, and the vice president wants to leave the company.
That's right.
Did he already leave?
No, already left.
He already left. And he wanted to just try to go work somewhere else.
Yeah.
And the company had a contract called a non-compete that said you're not allowed to work for anybody else that competes.
Yeah.
I mean, isn't that kind of like a career ruiner? I mean, he'd have to move to a different state or something, like take his kids and family and out of school?
Yeah, you have no idea. I mean, well, actually, you do have an idea, but a couple months ago, and I'll tell you just a little bit of a tangent story, is I had a guy working at a dairy farm, a dairy farm milking cows. And he calls me up.
He's like a farmer
He's
guy?
a farmer. He's a farmer. And he left that farm to go work at another farm. And he gets a cease and desist letter from a lawyer saying, you can't do that work at another farm. And
a dairy farmer?
As a dairy farmer. And I lost my mind. And I represented the person. I didn't charge him a penny or anything like that. And I just, wrote a really nasty gram, and sent it over to the farmer that says, I'm not going to charge my client. We're going to fight this, tooth and nail, and we're going to take this to court if we have to, because this is so ridiculous, right? This is not how people should act.
No, and it's worse. It's not good. I think it's harmful. It's hard on that VP, but I mean, it's even harder on a dairy farmer, right?
Yeah.
Like, what is he supposed to do? He's been a dairy farmer his whole life, and now he has to go to work at McDonald's or something,
Right. Right. You got to do, you're forced into doing something that's not you, right? That's not your fit. That's not your expertise. It's not what you learned how to do. And now a company is going to be able to tell you that you can't do it anymore. And so in this case that we had where the executive level employee left and goes to another company, goes to a competitor, it was just a scorched earth, really miserable back and forth case, number of attorneys on both sides. And the overarching goal of the plaintiff in that case, of my client, is to inflict pain on the other company, right? Because the other company is trying to take someone from them that does have some knowledge about them and what they do.
And sounds like a valuable employee.
Right, valuable employee. And so it just becomes a fight about whether or not somebody's going to be able to compete against us. Now, on the one hand, I think you hear that sort of story and you say, well, I get it, because You don't want your employees going and helping your competitors. The problem with that is it's very anti-free market.
Yeah.
It feels very un-American because
it just doesn't feel right to me.
Yeah.
I mean, it just doesn't feel right.
No, I mean,
if they were stealing trade secrets, like leaving Ford Motor Company and taking the blueprints and giving them to Chrysler or something. I mean, I understand that would be wrong, but
right.
And especially the poor dairy farmer, going across the street to milk a cow.
That's exactly it.
I mean, would he have a special udder technique?
No, I mean, it's just absurd. Jimmy John's got in trouble a couple of years ago because they had non-competes for all their sandwich makers. And at one point, those were being enforced. People were not allowed to go work at a Subway because they had at one time worked at a Jimmy John's.
That's ridiculous.
And it got really goofy. And then a court stepped in and said, no, we're not going to enforce it under those circumstances. But here in Michigan, we're still in a state. We were really close in November to having non-competes banned, and it failed. And so now, you're working somewhere, you get a better opportunity. You want to go work somewhere else and help your family out. You're not going to be able to do it in a lot of times because, lo and behold, you signed something back in the day, 10 years ago, 20 years ago, that said you can't work for anybody but us.
Yeah. So what happened with this vice president case?
So what you talked about trade secrets, I mean, that was our case. And we were trying to find, really hard working to figure out, did this person take anything? Did they steal anything? And in a case like that, you're going to, and this goes for anybody, kind of in a similar situation, is you get the forensic investigators, you start digging into somebody's technologies, you look at their phones and their laptops. It's a very expensive litigation.
How many lawyers did you guys have?
We had 5. The other side had 5 at least.
So did the guy's new company pay for his lawyers?
Absolutely.
Yeah. Okay.
Yeah.
So it's easier, again, like most things in life. When you have more money and you're in those positions, you are able to do that. The dairy farmer, unless you represented him, probably wasn't going to be able to afford 5 lawyers.
That's absolutely right. I actually give the advice, and I'm not afraid to say it. I will tell clients who have a non-compete sometimes that the best decision for them is to go into stealth mode. Yes, it's okay to leave. It's okay to go work for a competitor. I know you have a contract, but this isn't the Wild West. You didn't take an oath. Companies break contracts all the time. And I will tell a client that it's okay to break your contract if you think you're not going to get caught. And, that's, to me, that's sound legal advice because ultimately Michigan has a law, and the law says that the company can only enforce that non-compete if they have a legitimate business interest. And where I don't think somebody has a legitimate business interest, like the dairy farmer, of keeping my client down and preventing them from work, I'll tell them to go ahead and break that contract and try to do the work without getting caught.
Are judges sympathetic to the workers, or is it a mixed bag, or how does it go?
I found not at all. No, and that's been especially true in Michigan because we have what we call the business courts, right? And so in the business courts, if you're an employee being accused of violating a non-compete, you're going to end up in a business court in front of a judge who is the business court judge who wants to be the business court judge. And typically anybody who wants to be the business court judge has okay feelings, good feelings about businesses. And so if you're the employee that's stuck fighting against a business in Michigan's business courts, it's the odds are really stacked against you.
I had one non-compete case in my career. It was this guy. He passed away. God, what was his name? He worked for Orkin Pest Control. He was just a pest control guy. He left Orkin, started his own company. Now his problem was he took all the clients that he used to service at Orkin, said, "Hey, I'm going to do this for you for cheaper."
Yeah.
And they said, okay. It was called Noble Pest Control was the name of the guy's new company. And he did that. And so Orkin sued him because, Orkin is like a massive corporation, right?
Right.
And they threw all kinds of money at it and they sued him. And he hardly had any money. He's trying to start a new business. He's a pest control guy. He goes around and sprays. And it became a big thing. We had to go to business court in Oakland County, and we were in court like almost every week over this non-compete, and they were filing motions left and right, basically trying to shut down his business, ruin the competitor, and send a message to everyone else. Like,
That's right.
don't try to leave. You know what I mean?
Yeah, and it's one of the best examples we have in the law of how a big company with money can effectuate so many results, right? And in this case, you're scaring your employees to never leaving, accepting their wages, accepting their future is going to be what it is with this company, and you're preventing the brave ones from actually leaving.
Yeah, that's interesting. So, and lawyers, we don't have to deal with that. I think non-compete with lawyers are severely curtailed.
Not allowed in Michigan.
Not allowed. Yeah. So, all right. So, what other crazy stories do you have?
Just since switching to the plaintiff side, we've had. We got the religious accommodation cases,
which have been taking up a lot of your time.
Yeah, that's right. So I have one case. I'll throw one case at you. In one case, my client is a very valid whistleblower. Absolutely raised some issues at work. Gets fired right afterwards. We have a litigation. Okay. We have a lawsuit, and in the lawsuit, the company now files a counterclaim against my client. And the counterclaim, it's a public case, I'm going to talk about it. The counterclaim says that when you worked here, that your son got medical treatments here, and the owner of the company sent my client a note that said, we are never going to charge you for any of these treatments.
Is this a medical provider? Or
it's a healthcare provider.
Okay.
A pretty notorious one right now.
So the employee's son was sick.
He had autism.
Oh no.
Yeah, he had autism, and he was getting treatments from this company, and the company sued her to collect on his treatments.
That's despicable.
It was awful,
and they had told her that we're not going to charge you.
Yeah, absolutely. We had it in a note. They told her we're not going to charge us. Now, they filed that as a counterclaim in our federal lawsuit. But as you know, that claim that they had against my client had nothing to do with her whistleblower case. So I sent an email.
That's despicable. They're just trying to bully her to make the case go away.
Yeah. So I sent an email to the opposing counsel, and the opposing counsel sends me back the nastiest thing you've ever heard. Okay.
What does it say?
And he says, Noah, you just went from a lawyer that I've never heard of to a lawyer making incredibly unethical arguments that I have sent to everyone in my firm. And I'm going to say the name of the firm because, again, we've got filings.
Yeah, say it.
Varnum.
Ah!
And he says, and so everybody at my firm now knows how unethical you are. And we file our motion to dismiss. And in our motion to dismiss, we attach that email.
Good for you.
Yeah. And in the response brief, the lawyer says, Judge, I didn't actually send that letter. I didn't send that email to everybody at my firm.
He just lied to you?
He lied. He said, I was just trying to intimidate Mr. Hurwitz.
What?
Yeah.
This was in federal court?
It's in federal court right now.
And just so our listeners understand, look, federal court and state court is very, very different places generally, depending on the judge. But
yeah,
federal court is very strict, comparatively speaking, right? State court, I think they're used to like a little more lenient atmosphere, so to say, right? Would you agree with that, generally speaking?
Yeah, 100%.
On the judge,
Yeah.
That is not. So what did the judge do?
So that motion is currently pending before the judge still. And so our reply was, Judge, I can't believe that a judicial officer of the court just admitted that he lied to his opposing counsel.
And he lied to you, calling you unethical. That's
right,
like
right. The irony was incredibly rich.
Yeah.
And so we asked for sanctions, and we're waiting to hear what the court's going to do.
Oh, that's an interesting case.
Yeah.
Well, they do say some horrible stuff, and they do some. It's just crazy what some lawyers are willing to do or say. That's very disappointing to hear that.
Yeah, I tell the attorneys that work with me, I tell them we're going to be apologetically nice. I mean, like surprisingly goofy nice to our opposing counsel. We're going to treat them with respect. We're going to go above and beyond until they don't behave the same way. Yeah. We're going to give them every benefit of the doubt. We're going to try to do this thing the right way. And then sometimes they do drag you into the mud. And when they drag you into the mud, as they say,
I've seen you.
You got to get dirty then.
I've seen you get dirty.
Yeah.
We had in our case that our world record trial, we had, how many lawyers were on the other side?
I think at least, 7, 8, something like that.
7, 8. It was like every time I turned around, there was like a new lawyer there. So, and some lawyers were just like, it was so bizarre because it was like, oh, jury instructions. Then like some lawyer would pop up who I'd never seen or heard from before from like central office in Lansing, like, hi, judge, I'm here to argue jury instruction 32.8, or whatever it was. And, that's what they do.
Yeah, they try to, and again, we talked about how the law has favored employees. Favored the big companies.
Yeah.
And one of the reasons it favors the big companies is because for decades now, there's a lot of plaintiffs' attorneys that are just one lawyer, right? Two lawyers in an office, that's it. And so the companies always figure they can outwork us. And so it's nice when you have kind of enough brain power like we do at our firms where we can push back against that. We can throw a bunch of attorneys on a file too.
Right.
And we can fight it the right way.
And resources and know what they're doing. I always find too, if you can break through and you're a good trial lawyer, a good litigator like you, that, the house of cards on the defense often just crumbles down. Because when they get into a courtroom in front of a jury of people, that shit is not going to fly.
Right.
Okay. You can't, do that type of stuff and lie and all, the truth can be revealed that way. That's why I love our jury system.
Yeah, 100%. And the thing that I've discovered through working with you is that it's very different to have a case. When I was on the defense side, we didn't prepare our cases for trial, right? We just litigated our cases. We figured most likely we were going to get them dismissed. Having seen you and kind of understanding your methodology better, your methodology is, you mess around, you're going to find out.
Yeah.
And so,
fuck around and find out.
That's right. I didn't know if we could swear on this. So, but you're right. They do find out because you're litigating your cases from the beginning, like the case is going to go to trial. And so if the case does go to trial, you've got the ammunition, you've got the experts, you got the facts. And when that happens, the company all of a sudden, it's like the king without his clothes. I mean, everybody's going to find out at that point.
Yeah.
The tough part is, as you know, getting to trial.
Getting there, right? It takes a long time. This system is difficult. All right, we got time. Let's finish because I'm getting the time's almost up. But we're working on a case right now. Very exciting case. Very big case. We've been on the news for this case. Yeah. We've teamed up because we make a great team, the dynamic duo. So tell our listeners about this crazy, sick, disturbing case.
Right. So we've got a case now, as you know, where a former football coach at the University of Michigan seemed to really go overboard and go after the private information of all these student athletes, not only at the university, but all over the place in an attempt to get, nude pictures, nude videos, a lot of stuff.
Just innocent students. Many of them there's minors in this group. And so it's just a crazy case because we sort of know it happened. We don't exactly know the extent of it yet, but we know it's huge. And now it's our job to investigate and find out and try to protect our clients who this was kept a secret from. And that's kind of the most offensive, awful part of the case is they're only now finding out 2-3 years after everything happened that their information might be out there in the dark recesses of the dark web and on pornography sites and other places this stuff shouldn't be. Yeah, these young women, some of them girls, really getting a letter from the government saying, yes, this guy accessed your private photos, all your iCloud or whatever, and downloaded all of your private information off of your phone and stuff is scary. And one of our clients, he looks like he got into their Snapchat. Remember that? Yeah,
for sure. And no, just one of these things where when you're a student athlete, you have this relationship with the university, right? That university is there to take care of you. There's a fiduciary relationship, and so to find out that that your emails, that your private information, all that stuff was out there, that it was able to be stolen. Just a very traumatic thing to go through. And I'm getting calls left and right where the clients are just, want to know what's next, what's going to happen next. And I tell them, we're up against a court system that doesn't ever make anything easy for us.
No, or quick.
And so now we got to go dig. We got to go investigate. We get to put on our Sherlock Holmes, cap. And on this one, we really have to dig into what the hell happened.
Yeah, and we filed a motion with the court because for a lot of these young women, it's like, where is my stuff, right? Yeah. Like they are being told that somebody stole some nude pictures, for example, private, intimate things, personal things off of their electronic devices. And it's like, where is it, right? Like, we still don't have answers from the university on who has custody of this stuff, what was done with it, where did it go? And it's just creepy, man. It's just really, really creepy. It's like, can you imagine some strange guy out there downloading all of your phone stuff and then doing God knows what with it and where it is? I mean, it's just...
Yeah, definitely one of the wilder cases we've seen for sure.
Case has gone wild, baby.
Gone wild.
Well, Noah, thank you. Thanks for all the work that you've done. Thanks for coming on the show. I mean, we've made some major impact, I think, in people's lives and in the law. And I'm just so glad that we were able to connect, and I'm sure we'll be working together for the rest of our careers.
Sounds good, John. I appreciate you having me.
Good to see you, Noah.
Yep.
All right, everybody. Special thanks to Noah Hurwitz, religious accommodation lawyer extraordinaire out of Ann Arbor with his firm, Hurwitz Law. It was great having him on the show. Great guy, great friend. If you need help, we'll get you connected with Noah or anybody else. Give us a call, 833-MARKO-LAW, or go to our website, www.markolaw.com. We'll see you in another 2 weeks. Thanks for listening on another great episode of Cases Gone Wild.